Welcome to the 55 Connection seminar on Understanding Powers of Attorney. We are very fortunate today to have Joshua Horning present this for us. He's our Assistant Manager of Deposit Services, and so he knows a lot about this, and he is a great presenter, so I know that you'll really enjoy this. I'm so glad also that you know you are here close by so that you can engage with him and you can ask him any questions that you need to if there are some things that you think of when we're going through this. So it's not just a presentation where you have to listen to it. It's one that you can ask a lot of questions and he can answer. So without further ado, I'm going to give you over to Josh.
So
Thank you so much.
Thanks. Okay, and this will just a tad here. Okay, there we go. And if, like Aaron was saying, if you have questions or something, feel free to stop me, ask questions, whatever comes to mind or things. If you come up with questions afterwards, feel free to reach out to me or reach out to one of us in deposit services. And we can help you as much as we can. The first thing I do want to say, though, is that we aren't giving legal advice here today. So, with that, make sure that if you're going to, if you're really going to go in depth about the power of attorney and everything, go find a really good lawyer. You can ask them as many questions as you want. You can have them draw it up. You can just go online and find a power of attorney paperwork and fill it out through there. If you have in-depth questions, though, highly recommend finding a good lawyer, and then they can walk you through any steps that might come up, any questions that you might not think of, and stuff like that. So, like Aaron said, my name is Josh Horning, and I'm our Deposit Services Assistant Manager. And with that, here at the bank, we'll get into this a little bit more down the road. We don't have anybody, a specific power of attorney person to go to, but if you ask for deposit services, most of the time, the person that you get can answer most of your questions, most of the general questions for that. So, again, we're not giving out legal advice, so if you have more in-depth questions, feel free, please go find a good lawyer and deal with that. So what we'll discuss today, what is a power of attorney? So who is a power of attorney? It can have two different definitions realistically. An agent with power of attorney is the actual person, but you can also call the document that makes that person the power of attorney. That is also called the power of attorney. So the person that's actually doing the work of the attorney, in fact, can be called one, and the paperwork as well. We're going to go over how does a power of attorney work, and as we'll discuss shortly, the powers of attorney can be granted with limited authority, or it can just be general authority, and the person has access to kind of do whatever they need to make sure to help you financially or through your healthcare stuff as well. Why do you need one or more power of attorneys? Why should you have a power of attorney? That is a question that people ask sometimes, and it is very important to have them. All of us at some point we're going to probably start to struggle with finances, making decisions, or even if you're on trips or something. I know some of you were talking about going to Norway and things like that. If you're out of the country and you're over in another country, sometimes you can't really do everything that you need to be able to do financially while you're out of the country. So to have a power of attorney, it definitely helps because they can assist
Is
in
the power
that.
of attorney meeting?
It is.
Okay, I have two people here. Oh, sure. Right in here.
Welcome. Came just in time. We're just getting started here, so. And then so we'll also go over when is the right time to create power of attorney. Spoiler alert, now is the best time to create a power of attorney, but we'll go over more detail of that later on. And then lastly, whom should you choose? Whom should you choose to be your power of attorney, to be your attorney in fact? And as we go through the presentation today, those two terms are interchangeable, power of attorney or attorney in fact. So whichever one I say, just know that those mean the same thing. Okay. So, the phrase power of attorney, as I said, has two meanings. It can be the legal document, so the actual written out legal document for the power of attorney, naming the agent to act on the grantor's behalf, or it can also be the person that is giving authority that is granted to that agent. So it can have two different definitions, and but it's used, the same phrase is used for both of those things. So just don't get confused with that as we go through all of that. The grantor determines the scope of the agent's power. So basically what that means is the grantor, so if you're the one who is setting up the legal power of attorney, you're the one granting this legal authority to another person, to the agent, and you get to determine what they can do. If somebody is ever like forcing you to do something, like you must make me power of attorney for this reason, that would probably be a good reason to step back for a second, wait, and be like, why is this person wanting so strongly for me to grant them this access? Are they actually looking out for my best interests, or are they trying to benefit from it in some sort of way themselves? But you as the grantor, you do have all the power, all the authority. You can give them as much of that power and as much of that authority, or as little as you want. Power of attorney, the agent who is power of attorney does have a fiduciary duty to act in the grantor's best interest. So basically what that means, being a fiduciary, means that legally you have to act in the best interest for that person that you are doing these services for. So if that person, if it's found out that that person was siphoning off money, stealing money, there are legal recourses to go back and try to get some of that money back. Hopefully that the person that you are giving this authority to, you do trust them and they never do something like that to you. Unfortunately, that is not always the case. We do live in a world where people are sometimes just looking out for their own interests and they don't really care about that other person that they're stealing money from, realistically, is what they're doing. So they do have a fiduciary duty, though, and you do have legal rights to go back if they are stealing the money to get that investment.
Is there any benefit to having two people as power of attorney in that case?
There is, yes. And so we'll go through that.
Okay.
Because there is benefit to that, because if you ever stop the one person from being it, the other person still can.
Okay, one person.
Can do that. Exactly, yeah. If somebody passes away, you can set up like successor power of attorneys and stuff like that. So yeah, but yeah, there is definitely benefit to having two people.
Are there
That's it.
negative side, or are you going to cover that later?
There is a little bit, we'll go over that later
Okay.
as well, but there can be definitely positive and negative
Okay.
to having two people on there. Yeah, so I personally think it is more positive to have two people. It's kind of more so the way that you set it up though. So we'll go over that here in a little bit though, for sure. Okay, so types of power of attorney. There's two categories of power of attorney: authority for financial and legal matters, and authority for healthcare decisions. The healthcare decisions, that can kind of be looked at almost as a healthcare directive. And obviously the financial and legal matters, that is somebody who if you want them to have access to your bank accounts, you want them to be able to pay bills for you, you want them to be able to, if you have stocks or brokerage accounts, they can make trades for you, those types of things. That would be the financial and legal matters. The healthcare decisions is realistically mostly for end-of-life decisions. It can also be for just if you go in to have surgery and something happens and that person needs to make a decision, that can also be a big thing. I'll just tell a quick story about that. So I have friends that are actually, he's I think only about 45, she was like 42, and she had to have neck surgery. 2 vertebrae, I think it ended up being 3 vertebrae they needed to fuse together. And so during that process, everything seemed to go well with the surgery, but then coming out of it, she was having lots of issues. So much so that she was like, they were honestly telling my friend Sean, hey, there's a chance that she might not make it through this. So he's obviously kind of worried and everything and trying to figure out what's happening, what's going wrong. Long story short, they were in the hospital for like 3 days straight, not knowing what's going on. And it ended up the medication they were giving her, the pain medication, she was basically having an allergic reaction to it. And she kind of knew this because her sister had also had an allergic reaction in that same way. And so she was not getting like any relief from the pain. And on top of it, she's like throwing up constantly and can't keep any food down. It was a horrible situation. But because he had healthcare power of attorney, he was able to basically say, we're done taking this pain medication, we're going to switch to this one. And the doctor was like, I don't know if that's the best decision. He's like, nope, that's the final decision, we're doing that. About 13 hours, I think he said, after they switched the medication, she wasn't completely fine, but doing way better, able to keep food down, and she got released from the hospital at that point. So that's why it's so important to have like, these types of things in place, because if she hadn't, and they just kept giving her this medication, who knows what would happen. But just something to say, like, this is really something we do need to think about, because obviously my friends, they were in their early 40s. Nobody's thinking that anything horrible is going to happen, but things can happen. So
Were they married?
they were. Yes.
So they recommend that you are the power of attorney for your spouse versus you don't have the right to make those decisions without that?
You can, yes. So it depends upon every situation. It can be a little bit different, but the best way to do it would probably be if you trust your spouse completely. I would put them as the power of attorney, but then I would also have like a successor set up so that if you're like in a car accident or something and they become incapacitated as well, somebody else can step in also. But if you trust them explicitly, I would set them up, and then after that, I would also have successors in place as well. Yeah. Okay. So for these 2 types of power of attorney, they can be granted separately. So if you have, let's just make this easy, if you have 2 kids, one of them is very smart financially, the other one, you know that they have the exact same healthcare decisions and mindset as you do. You could set up the one as your financial power of attorney, you could set up the other one as your healthcare power of attorney. They don't have to be the same person. Lots of times they are the same person just because that's the person you trust the most, but they definitely do not have to be the same person. So it can be 2 separate things, and most of the time, I would say probably 95% of the time at least, you are going to have 2 completely separate documents, one for financial power of attorney, one for your healthcare power of attorney, because the bank doesn't need to know and doesn't care about your healthcare aspect of it. The hospital doesn't need to know or doesn't care about your financial aspect of it. So it's best to have 2 separate documents for that as well. They do share certain similarities though. They are governed by state laws. They do both end at the grantor's death. So if you are giving the power of attorney to somebody, if you pass away, that power of attorney ceases. That's a whole different topic of what to do after you pass away with wills and executors of estates and stuff. And we actually have other little seminars that we go over with that as well. But for this purpose, you just need to know at your death, power of attorney ceases. And that is something important to tell the person that you are giving power of attorney to, the attorney in fact, because we do frequently have people come into the bank and they say, hey, I want to do this with my parents' accounts or whoever it is. And we have to tell them, no, sorry, you can't do that, like you're not on the accounts and they passed away. And then they say like, well, no, I'm power of attorney. And it's like, sorry, but that doesn't continue to go on after the person passes away. And then it is important to name alternates, like we've talked about a little bit already. Successor power of attorneys, it is very important to add that person in for the reason that if it is a spouse, you both are in a car accident or something happens to both of you, somebody else can step in and take that place. Or if the person that you have as your attorney in fact passes away, you don't have to go draw up new documents immediately. That successor can just step in and take that role as well. So definitely helps a lot to have that in place.
So in naming the
Successor.
there we go. Do you say like specific circumstances where they step in? Or
Yeah.
is it governed by the law when they come in?
So it can be, most of the time it's governed by the law, because in like just the general power of attorney that you can pull up, I can't remember the exact Minnesota statute, but if you pull up like Minnesota statute POA, it'll pull up a generalized form. And in that form, I believe it states like if the original power of attorney is unwilling or unable to complete their duties, then the successor can step in. So that's something to note as well. The successor doesn't have any access to be the power of attorney until something happens to that original person.
So
So
they should be on that account then as well, is that what you're saying? Make sure that all parties are on that checking account or whatever?
yeah, so you can for sure set it up like that. It makes it a little bit easier if you were to pass away, but that's where power of attorney is kind of nice because let's say if the person you have as power of attorney lives over in Wisconsin and they can't come to Minnesota frequently enough, and so you never get them added as like an owner signer onto the account, but as long as they have power of attorney, if something happens to you, they can still walk in with that power of attorney saying, hey, I'm able to help out with their finances, give that to us and we can still allow them to have access to that account. to
So
help out.
they wouldn't necessarily need to be on the account then?
Correct.
Okay.
Yeah, they don't necessarily need to be on it. Okay, so how is a power of attorney created? The grantor must be of sound mind. That's why we do say do it as soon as possible. My wife and I, we actually already have power of attorney set up as well. It would be my brother-in-law at this point who would be it. But make sure to set it up as soon as possible, because the longer you wait, the more chance there is of something happening to you. And if something happens to you and you don't have it set up, if you're in the hospital, you can't get something notarized, you can't get somebody to fill out the power of attorney paperwork for you. Unfortunately, you're kind of stuck at that point. Or if something majorly bad happens to you, the state will basically say, this is the person who now has authority over you. That would be conservatorship or guardianship. The state would then decide who is going to determine your finances and everything like that. So I don't know about you guys, but I don't really want the state to determine who that is for me because they don't know my life, they don't know the people who are around me. Thankfully, at this point, me and my brothers all get along very well. So if it was my brothers that got granted access, I would trust them to do it, but it might be in some cases where a sibling, you're fighting with them, you're mad at them at that time, they get granted guardianship of you, and now all of a sudden they have access to your finances and get to decide what happens. The state doesn't necessarily know that. The state's just gonna say, oh, you're the sibling, you're probably gonna act on their best behavior, or best interest, sorry, and they'll give it to that person. So set this up as soon as possible because you do have to be of sound mind. So if somebody can basically come back and say, no, Josh was not in his right mind at the time that he set up this power of attorney, that can get voided and it can go away on it. Yes, ma'am.
When your power of attorney ends then at your death, it's the will that takes over then as what happens to your finances and
Correct, yep. Yeah, depending upon what you have set up, if you have a trust set up, usually that will go into effect and that will take over. But if you have a will set up, then that will be what takes over.
you don't need both if you have a trust.
You don't necessarily need both. I would say it's a good thing to have both because a trust is definitely a little bit different than a will. But yeah, it would be beneficial to have both, especially if you have any sort of assets when you pass away, for sure. Okay, so power of attorney always has to be written, and I know for our case, we won't accept one if it's not notarized. So I would just say, as a rule of thumb, has to be written out, has to be notarized. It can't just be a handshake deal. Hey, I want you to be my attorney in fact. Great, now what's up?
So the format you could print out online could be what you'd have notarized and signed, like
Correct.
that, okay.
Yep, exactly. And if you ever go online and you find it, it's pretty basic and it's pretty simple. Like, realistically, you could print it out, fill it out, and have it notarized within 5 minutes if you really wanted to. Again, I would recommend going and talking to a lawyer and just making sure that you're covering all your bases, but you can do it very, very quickly. There are online forms available. Again, like I said, though, but preferably use an attorney. It can be handled in conjunction with your will. So we'll get into this down the road a little bit with the healthcare power of attorney, but if you have a living will, you can specify in there that you have power of attorney and stuff. The POA can be customized to meet your wishes. It can be very specific of this person can do these exact things on these exact days, or it can be very broad that they have absolute control of my finances and I'll allow them to do anything up until my day of death. An attorney can also advise on the powers automatically included. Because there are some, just depending upon the state and everything, there are some powers that are just automatically included in the power of attorney. So that's why it's always best to go to an attorney and have them help out with that. Okay, so who should serve? Choosing an agent to be your power of attorney. This handout here is, I think, the only one that I'll specifically talk about today, but choosing an agent, it is a very, very important decision. Like I said, you're giving this person complete access to your accounts in most cases, and so if they are not a trustworthy person, if they're in their own financial debt, if they're about to file for bankruptcy or something and they need your money, you don't want to be giving them full access to your accounts, and all of a sudden you got $10,000 in your account, and 2 days later you have $1,000, and you're like, where did all that money go? So make sure that they are a trustworthy person, for sure. Make sure that they're familiar with your wishes. If you land on opposite sides of whatever spectrum you want to use, it's probably not the person that you want to set up as your POA, especially when it comes to medical decisions. If you are somebody who you're like, I do not want to be kept alive mechanically in any sort of way, just let me pass away. Don't set somebody up as your medical power of attorney who's like, no, I'm going to keep you alive no matter what. And same thing financially. If you're like, I want to try to basically give most of my finances away before I pass away to different charities and things like that, don't set somebody up as your POA who's like, no, you have to save, 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 never give any of it away. So depending upon what your wishes are with your finances or your health care, make sure you have a conversation with that person you're setting up as POA so that you are on the same page there. Be confident and knowledgeable of the decision maker. If any of you wanted to set me up as power of attorney at this point, I would probably be pretty leery of that, and I'd be like, you don't even really know me, like, let's pump the brakes on this. You should probably know this person in a very good way. Know, like, who they are, what they represent, if they are in financial trouble, know all of those types of things, because you don't want to give access, again, to somebody who's going to take advantage of that. Make sure this person is able to withstand criticism and potential conflict. If this is a person that basically just rolls over and is just like, whatever, I don't want conflict, so I'm just going to do whatever the other person says, again, that's probably not somebody you want as your power of attorney, because being power of attorney, more than likely, there's going to be some hard decisions for them to make at some point, financially or medically. And you don't want somebody that's just going to give in to the first thing that they hear and say, well, I know Josh wanted it this way, but his brother said he probably would have wanted it this way, so I'm just going to give in to the brother, and I don't want him to be mad at me, so I'll just do what he says. Make sure it's somebody that has a little bit of a backbone and can actually stand up for your wishes. Make sure it's somebody who's a clear communicator as well, that they can be clear with what they're doing. If they are somebody who isn't good talking with other people, sometimes that's not the best person, because most of the time when power of attorney has to go into effect, it's in a difficult situation. You want somebody who has a level head, who's going to be able to communicate your wishes to whoever they're dealing with in a very clear, concise manner, especially when it comes to healthcare decisions. Sometimes it's literally just a split-second decision. They're about to bring you into emergency surgery. That person needs to know and be able to communicate that to the doctors, the surgeons, whoever it might be. One agent only. This is the one thing that I kind of differ on a little bit from this slideshow here that American Bankers Association puts on. It is good to have only one agent, because that's the person making all the decisions then, and then you can fall back to who made that decision. Depending upon your situation though, sometimes it is good to have two people be in that position, as long as they're two people that you know they get along well and that you can trust both of them explicitly. Like I said, if something happens to that person, if they're further away than the other person at a time, if they went on a trip and the other person isn't, that way you always have somebody who can act as your power of attorney. The one thing I will say about that though, usually it's better to not have them work as they both have to be in agreement, or they both have to sign everything. Because if you do that, we have had that in the past here at the bank too, where it says they set up two attorneys in fact, and they have to both be there, make the decision, and agree on the decision before something can go forward. One of those attorneys in fact come into the bank and they say, hey, I have POA, and they give it to us, and it's like, unfortunately, I can't do anything with this because the other person isn't here to agree to this as well. So,
So how would you have it written up then if you are having two people
yeah.
and you're only having one to make one decision? You decide who that person is that's gonna make it? I mean,
Yeah, so you can set it up as, I'm drawing a blank right now on the exact wording of it, but it basically states that, dual, sorry. That's exactly what I was thinking of. You can have dual power, where it's like they have to work together, or separate power, where both of them can do the job, but they can do it separately. So, it would
so
be,
one would be finances and one would be health. Is that what you're kind of saying right now or not? What if it's, you got two people on the finance?
yeah, so you could have two people on the finance, and as long as you don't set it up as dual power of attorney, where like both of them have to be there and present to do it,
Okay.
you can have it as separate power of attorneys where they both have access and they both can do the power of attorney needs, but they don't have to do it together. So that would be a good way to set it.
So this is through the banking, but are these still the way you would look at if you're choosing someone for medical? You still would want someone trustworthy, agree with your wishes, or familiar with them?
Yeah.
Okay.
Correct. Yeah, I would say all of these things go for both of them. And we will talk about specifically healthcare at the end here for a little bit. But yeah, for this purpose, I would say both healthcare and financial, you want them to line up with all of those things. So lots of times, it's family member, close friend, or a professional. Again, like I said, we don't have anybody here at our bank that is like a professional attorney in fact for somebody. I know there are some financial institutions that do that though. But it doesn't have to be that way. And the one thing that you run into if you do a professional, lots of times you'll have to pay that person. So that's where family member or close friend kind of is nice from the aspect of they, you don't really pay that person, so. Okay. And so financial powers and limitations. So you as the grantor, like I've talked about already, decides on the powers given to that person. It can be anything you can do yourself, or you can limit it by task or a time period. What your agent cannot do in most cases is make decisions for you while you are capable and willing to make them yourself. So if I'm still completely in my right mind, still functioning like normal and everything, my power of attorney can't necessarily come in and just start making a bunch of changes to my accounts. If I am still willing and capable to do it myself, I still have full authority. I haven't necessarily given that over to them yet. It's set up to where they're going to be able to, but I haven't necessarily given that over.
So where does that come into where you decide that that person is not capable? So me being a sibling to two parents, I'll just use an example. So all of a sudden there was like $1,000 given to something that was like an organization or something like. So do you look at that and say, okay, is that okay? Not, you know what I mean? So how does that fit into disagreeing?
So that's where power of attorney is more you can help with the things that you're doing, but you can't hold back on the things that they're doing. Go ahead.
So, okay, so you can't, but what happens if that person really couldn't afford to do that? This has happened to somebody recently in the past year, and it got to be thousands and thousands of dollars, so I'm just kind of trying to figure out.
Yeah, that's where you almost have to take it to the next level, and you have to get like guardianship or conservatorship for that person. That would be through the court system then, and then if they grant that to you, then you would bring that into the bank, and we would basically, if it was you for your parents, we would put you as the signer on the account, and now your parents don't have access to it anymore. So that would be like another level to it. But power of attorney, you really can't stop them from doing anything. It's more just helping them to fulfill their wishes, or pay bills and stuff like that. But yeah, that would be something I would go bring to the courts and try to get it that way. A power of attorney cannot select a replacement agent with POA. So if my parents gave me power of attorney over their stuff, I can't come in and now say that Aaron is now allowed power of attorney over my parents' stuff. That is for their decision to make, and the attorney in fact cannot make that decision for them. You can't just change it. And they cannot violate the fiduciary duty to act in your best interest. So, in that type of a situation, but reverse it, that person can't just go out, the power of attorney can't just go out and take $1,000 off and say, well, I want to give it to whatever conservation program. They can't decide that unless that person they're acting on behalf of is actually okay with that. If they do that without that person's knowledge or willingness to want to do that, that's where it can come back on them. They might have to even pay restitution for the decisions that they make. Okay, so now specifically financial power of attorney. I know most of the stuff we've been talking about has been the financial side of it, so some of this will kind of breeze through a little bit, but the types of powers of attorney, it can be limited, general, durable, or springing, sometimes called conditional. So limited power of attorney is usually for those very specific cases. So like you're going to Norway, if you do go to Norway, you can set up a power of attorney to where you can say on whatever date you leave for it, March 13th, 2026, this person has power of attorney. They only have that ability though until March 25th, 2026 when I get back. Yeah.
So then would you fill in another form?
Correct.
So you'd have two, you have your like to take care of your will, your health care, but this is just for your vacation or whatever you leave the country.
Correct.
So you
Yep.
pick up, okay.
Exactly. So that way it's like if your spouse is the power of attorney for you,
Right.
but you're both going on the trip together, you want somebody back here who's able to take care of your finances, you can designate somebody else for a specific period of time so that you can help with my finances, pay my bills, do that type of
Or
stuff.
you could just leave it as the first one, you have two, then correct?
Correct.
You don't have to.
Yeah, you don't
If
have
you're
to.
just saying like a certain date of time, you're giving a
Yeah.
month or whatever it is.
Yep,
Okay.
exactly. Yeah, so that's more of a limited one. Limited can also be from the sense of, let's say you snowbird down in Arizona and you have property up here that you want to sell, but you don't really want to come up here in the middle of January in the freezing cold to sell that property. So you give power of attorney to somebody else specifically to sign to sell that property for you. And that does happen more frequently than you probably would think. But you can do that where it's like, for this specific purpose, I want this person to be able to sign for me to sell this property.
So that's a separate paper,
Correct, yep. Again, that would be a separate one than just your general one.
and somebody have to notarize that then too?
Yep, yep. Usually though, it's, so if you're doing it for like a real estate purchase or sale, you can usually get that notarized and have them mail it up here. And then your agent, your real estate agent can look at it and be like, okay, they're giving this person access. And
So they don't have anything set up online where you can like I've done it through banking, we've been gone, well, they'll send it to you, you sign it, send it back. Can you do it that way or not?
you can.
Okay.
Yeah, it depends upon the situation. I know there are some real estate things that like,
You probably
it
can't.
has to be in person. So that's where that would come into play. But there are a lot of things that we can send through online or DocuSign.
Because there's so many codes and passwords that they use to it, so would it be smart to set that up just in case you could not get back? You would
Yes,
have those passwords to do it online?
correct.
Okay.
Yep, yep, that would be a very smart thing to do for sure. Yeah, so that's just a couple of cases for limited power of attorney. General power of attorney is basically, I'm giving you access to all of my finances, all of the decisions that I make for selling my real estate, making stock transactions for me. That's more what general power of attorney is. And durable power of attorney, that is basically, it goes into effect until the person passes away. So general power of attorney is usually durable power of attorney as well. It doesn't necessarily have to be. You can have general power of attorney that ceases if the person becomes incapacitated. I have never seen that in any sort of situation, but you are able to do something like that. But durable power of attorney would be, which is in most cases, that's where it goes until the person passes away. Springing power of attorney, sometimes called conditional, that's where something has to happen for the power of attorney to go into effect. So if you want to set a power of attorney, you don't want the person to be able to do anything until you become incapacitated, you can set it up that way. That would be springing power of attorney, where if I become incapacitated, I'm stuck in a hospital, I can't complete my finances, power of attorney goes into effect, and now that person can take care of that. That one is a little bit more difficult because usually if you do that, the financial institution that that person is going to bring that to is probably going to ask for something showing that you are incapacitated, like a doctor's note or something like that. So I can see why some people would want to set it up that way. But going back to some of the original stuff, if you trust this person with your finances, it shouldn't necessarily be something that you all of a sudden now you're incapacitated, now you trust the person to deal with your finances. You should be able to trust them even before you become incapacitated to just not do anything, not steal any of your money. So, but springing is where something has to happen for the power of attorney to go into effect. And then the POA enables the agent to act for you using the powers you grant. So again, they can only do the things that you tell them that they can do. So we kind of already went over this, but durable or springing, durable lasts until the grantor's death, becomes effective when signed. The grantor continues to manage affairs while they are able to, and the agent can assume control when the grantor is no longer able to. Springing, like we talked about, lasts until the grantor's death, becomes effective only after an event such as incapacitation. The document should detail how event or incapacitation will be verified, and then the agent's ability to act contingent on that verification. So again, springing is kind of one of those things. It's not always the best thing to do because usually you have to get something from a doctor that says, yeah, this person was in a car accident, they're in a coma, they can't do their finances, without the power of attorney can go into that. Okay. The typical financial responsibilities. The POA can manage day-to-day finances. So whether that's writing a check to your friend for $10 because they took you for coffee or something. Usually it can be to buy and sell investments, handle real estate or vehicle transactions, file your taxes, or apply for the grantor's government benefits. So that would be like Social Security or VA benefits, that type of stuff. Filing the taxes, you would want to talk to your tax attorney or your CPA about that part of it, because usually I think they need a little bit more, like you have to send in the power of attorney with your taxes when you file them to show that that person actually has the ability to do that, but kind of already gone.
So they would actually file your last taxes and your power of attorney, correct?
No, so the power of attorney wouldn't file your last ones, that would be the executor of your estate.
Okay.
Yeah, so this would be in the case where, I've had it before where customers, they have like dementia or Alzheimer's or something. So they can't really do that for themselves, the power of attorney can then file their taxes for them, so.
And they can do that up until the death then?
Correct. Yep, yep, they can, usually as long as it's a general power of attorney, they can do it up until they pass away. And I should clarify as well, more times than not, when the person passes away, the executor of the estate, or they are usually the person who had power of attorney for that person as well. So it usually just transitions. You have to go to the court system and get that all legal and everything, but usually you just transfer from power of attorney to executive more times than not. Bank power of attorneys, this is something that we don't do here at our bank, but some banks, some financial institutions, they do have a very specific power of attorney. You have to use their documents for power of attorney to be able to be used for that financial institution. So if you have any accounts at other banks or with like brokerage firms and stuff like that, double check with them and ask if they have a specific power of attorney that you have to fill out for them. Lots of times they will require that it's signed by both the grantor and the agent. I know here at our bank, the agent doesn't necessarily have to sign the power of attorney to make it legal for us, but some of the banks do require that. Sometimes the bank POA allows your agent to handle bank transactions, so it would just be for that specific financial institution that they're able to use that for. Some states do require banks to accept valid POAs that meet state standards. I don't believe Minnesota is one of those states, but some states do require you have to go, that if you provide a power of attorney to that bank, even if it's not their specific one, they still have to honor that. That's something
Because it
else.
would be notarized by someone else.
Correct, yeah, it has to be.
It wouldn't be by
notarized.
your bank that you're, so
Yeah.
you're saying it doesn't have to be notarized through First National, but it could be from another facility, whatever, but you
Yeah.
still would have to accept it?
Correct, yeah, in that case, yeah. And that reminds me too, each state is a little bit different for the most part. There's, I can't remember what it is, it's 20-something states that are all the same now, but there's still a lot of states that have different variations. So if you do move to Arizona or Texas or Florida or wherever it is during the winter, double check down there that the power of attorney that you created up here in Minnesota is actually valid down in those states as well. Because that could be a problem that you run into if it's not actually valid down there. Okay. Compensation. So this is what I was talking about with professional power of attorneys, professional agents. Sometimes you do have to pay out compensation to them. If the agent is paid, though, details should be in the power of attorney document. They can state the individuals may or may not be paid. Like I said, professionals typically are. So if you're setting up like a lawyer or somebody like that as your power of attorney, more than likely just expect you're gonna have to pay them at least something. And it'll usually say it in the document, like every hour they work on it, you have to pay them $100 or whatever it might be. So just know that for going forward. It can be a specific amount or it can be an annual percentage. So depending upon what they're doing, it can be a very specific amount that you have to pay them each month or annually or for each service that they do, or it can just be an annual percentage of if they've helped with $20,000 worth of stuff, you have to pay them 2% of whatever it might be. If they are a professional agent, they may require bonding, which is basically you can go to an insurance company and they can purchase it through that insurance agency. It basically is like, depending upon how much money you have and everything, it can be $1 million, it can be $100,000, but if that person does something to affect you where you lose like $50,000 or something, that bonding can go into effect and it can pay you out that $50,000. Usually that is only with somebody that you are paying for services like this. The compensation rules do vary by state. Again, if you're going to some other states, double check with a lawyer down there and make sure that what you have in your power of attorney that you created up here in Minnesota actually goes over to that state. If it doesn't, you'll have to go ahead and create one.
Going back to your bonding, okay, so I have a couple things.
Yep.
What if you have a couple businesses and what you're already bonded, can it go through that or not? Does it have to be a specific bonding? Like it's a specific for one of the businesses, the other one has its own, but you can't use that for that. I'm assuming.
I don't believe so. I think it has to be specific to
Okay.
that
Okay.
power of attorney. Yeah. I'm pretty positive. I can't say 100% on that, but I'm almost positive it has to be specific to the power of attorney. Okay, so if you decide to change your mind, and you don't want the person who you set up as power of attorney or attorney in fact to do that anymore for you for a variety of reasons, they moved away, you just fell out of your good graces, whatever it might be. The way you go about canceling that power of attorney, you do have to sign a revocation form and have it notarized. That has happened a couple times here at our bank where somebody comes in, they're like, I have power of attorney, and we're like, no, you don't. The most recent power of attorney that we have on our system says that you're not power of attorney. They're like, oh, well, that person was the old one, now I'm the new one. It's like, you have to provide us documentation for that then. So you do need a signed revocation and have it notarized. Best case scenario, you aren't required to do this, but it's smart to do. To notify that agent, your attorney in fact, in writing, and request that document back. Again, it's not a requirement, but it's best case scenario so that they can't go somewhere else and say, hey, I have power of attorney for this person. Yes.
So the document that you're requesting back, when they present this as part, is it always the notarized copy?
It
Like,
is.
you know, a lot of times you'll have that raised seal. So they couldn't just make like 10 copies and hand it out.
You could, so we would probably accept that here, as long as we can tell that it was like notarized and signed and everything like that.
Okay.
There are some financial institutions though that I know for a fact won't accept it unless it is that original.
The original.
They'll probably make a copy of it and give you the original back,
Okay.
but sometimes they won't accept it unless it is.
So would it be a good idea to have more than one notarized copy?
I know I ask people that if I'm notarizing a copy for them, like, do you want to, like, actual original copies of this, or do you just prefer one? And, so yeah, it kind of depends. I would say it's better to have two originals, so to speak, for those cases, especially if you have to send it out in the mail to one of the financial institutions, you at least still have an original in your hands.
So then if you would change, does that mean you have to go back and change it in your will and your trust as well?
If it's in there, yes, yeah, you would have.
So then you're better off not to put it in there or to put it in, or,
I would say it's better to just leave it out of the will, because the will doesn't really go into effect anyways until you pass away. So at that point, it's better to kind of just leave it out, because then if you do make changes to it prior to that, you don't have
what
to.
about a trust?
As well. So trusts
Can you have
are,
it separate?
yeah. I would keep it separate out of a trust, because a trust is going to be so much more specific to like, if this, then this, if this, then this. Whereas power of attorney isn't necessarily involved in the trust as much as like whoever the trustee is. If they set up power of attorney, then that power of attorney has access to the trust, but they don't necessarily need to be named in the trust at that point. If that
Keeping it out
makes
with
sense.
probably,
Yeah, keeping it out is usually the smarter thing, because then you're not paid to have it modified.
Yes.
Newer power of attorney usually states it supersedes the prior ones, so that's why for us, I know at least, and I would assume most financial institutions and just most institutions in general want to have an actual date. When did this power of attorney go into effect? Because if you have one that went into effect January 20th of 2020, and then there's another one that went into effect January 20th of 2023, if it says on there that it supersedes any previous power of attorneys, you would go with the one from 2023 then at that point. You don't necessarily need a revocation. Again, it's best to have that, but if you can see the two dates and it states in there, it supersedes any of the
so
others.
keep the old one attached with your copies.
Yep, yeah, that's exactly, yeah. Legal help, again, is important for this. Sometimes it's essential for it. And there are some state laws. Minnesota does do this, but state law does terminate POA after a divorce if your spouse was the agent. So,
Then you just print out a form and do your own separately after everything is.
correct. Yeah, so you don't even have to revoke it at that point. It's already been revoked. Yeah, so, which personally I think is a smart way to have it, because if you're divorcing them, there's obviously
So I
reasons for
do
that.
have a
so.
question, just for the fact that, okay, so I'll give you an example. So if you have your will set out and so my husband wants to have one person and I have a married couple over here, so we have three.
Yeah.
He passes away, then would I have to go back in and do another POA, so it's just for me only? And that would take rid of that. That one would be gone, like, you know what I'm trying to say? Because
Yes.
it's joint together, but what if something happens to him? So do another one for yourself and keep that one with your copies?
Yes, yeah, I think I know what you mean. So if you have one set up together, kind of, but he passes away,
Yep.
yeah, I would say it's best to just,
Go get it.
for, yeah,
Okay.
to make it clean and everything, it's best to just go get one.
Okay.
I don't believe legally you have to,
But just to me, because it would,
yeah,
I don't know, I think for whoever's taking care of it, make it easier for them.
correct.
So a POA doesn't have to be on an individual basis, it can be a,
So power of attorney does. Sorry, were you referring to?
No,
will, or-
it's together, but we have three people. He wanted one and I have a married couple. So the three
you have two people.
For the power of attorney.
for a power of attorney.
Okay, so
Just
I
for
was
power of
thinking you were
attorney.
talking about the.
Only, no, just a power of attorney.
Okay. No, in that case, it doesn't really matter, because as soon as he passes away, then that ceases. So then, if they had power of attorney for him, it doesn't matter anymore, because the person who was power of
Would
attorney.
it have to state that in that POA is what I'm, because we just have, like I said,
No.
we've chose three,
Yeah,
and then so that I wouldn't have to do another.
correct, you wouldn't have to.
Okay.
Yeah, because
Okay.
as soon as he passes away, the person he has as power of attorney for him, that ceases and then
Gotcha.
it goes.
Okay. So they couldn't interfere with, because it's not my choice, but if I wanted to change and not have that person, I could change it after death. But you find what I'm kind of.
Yeah, so it wouldn't, yeah, you could remove that person off of
Okay.
it. Yeah, just have the two that you want. Exactly. Okay, so healthcare power of attorney. We'll go through this a little bit quicker here, because a lot of it is redundant from the past, but there are some other things that you need to know about with it. So healthcare power of attorney and living wills, also known as advance directives. So most of the time, if you're talking about a healthcare power of attorney, a living will, or an advanced healthcare directive, they're kind of all the same thing, just a different name for them. I know there are some hospitals and things though where they like explicitly say you have to have a healthcare directive on file with us before you go into surgery or something like that. So then you would have to get that set up. But the healthcare power of attorney, it authorizes the agent to make the healthcare decisions for you when you cannot. So like in the case of my friend, he was able to make that decision for his wife because he had healthcare power of attorney. Living will states your healthcare wishes. So it's one of those things that basically, depending upon what is happening, I believe usually in a living will, though, it kind of is more so if the person needs to go on medical assistance to stay alive, that's usually more so what a living will is specific for, whether you want to be kept alive or just be pulled off life support. Whereas healthcare power of attorney can get a lot more nitty-gritty and specific about stuff. The agent, it's same thing with this, they do have a fiduciary duty to act in your best interest and in keeping with your wishes. That's why healthcare power of attorney, it's good to get specific with it, because if you want your healthcare to be a very certain specific way, I don't want this or I do want this, put it in your healthcare directive or your healthcare power of attorney, because then that agent can basically walk up to the doctor saying, they didn't want this, here's the healthcare power of attorney that says it, I'm making that call, and they can go from there.
If you were a donor and it's on your driver's license, would that have to be in your healthcare?
It doesn't have to be, it would be smart to put it in it, but if it's on your driver's license, that's good enough to have it on there. But I would say if you want to be 100% sure that it actually happens, yeah, go ahead and put it in your healthcare power of attorney. It would be smart to do that. Typical healthcare power of attorney responsibilities: authorize medical treatment, make medical decisions if the grantor lacks the capacity to choose, interact with medical providers and family, and choose extended care facilities. This would be something where choosing an extended care facility, if you have a specific one that you want to go to, put that in your healthcare power of attorney, because that way you might not be able to get into it right away. I know that happens a lot of times, but then you can at least get put on a waiting list and get put in there if that's where you want to be for extended care. Most of the other stuff we've kind of already talked about, so through that. So the essentials: accepting an emergency, medical providers need permission to treat you. So unless it's an emergency, you're in a car accident, the ambulance is bringing you into the ER, obviously they're going to treat you to keep you alive. But more times than not, if it's for different things that don't involve an emergency, it needs to happen right now to keep you alive, the medical providers do need permission from you or your healthcare power of attorney to do those things. So that's why it's good to set that up. The existence of healthcare power of attorney should be known. So if you're going to be going into surgery or something, make sure your doctors do know about that. The agent should have a signed and notarized copy of it. Make sure you get that to the person that you set up. Provide the physicians in the hospital with a copy, and keep a copy with your insurance documents. Family should know as well who that agent is, because you don't want siblings or your kids coming in and there's four of them trying to make a decision, and it's like, nope, this one person is the one to make the decision. Again, going back to who you're picking, that's why you want it to be somebody who has a backbone, who's going to say, no, mom said she wants it this way. I don't care what you guys are saying. She told me this is how she wants it. That sounds good.
Is the living will you have with your hospital or doctor,
Yeah.
is that takes place in this?
It kind of does, depending upon everything that you have in it, but it can very well take the place of it. Yeah, it's not a bad thing to have both, but it kind of is, it's very similar to this, and it can take the place of it, for sure. Yes, ma'am.
So, both my kids live out of town.
Okay. Yeah,
Would you recommend someone locally?
I would.
Okay,
For the reason that, if something happens, I know that's my parents, they live down in Chicago, and I have a brother like 1 hour from them, 2 hours from them, and then me and my other brother live up in St. Cloud and I'm up here. It wouldn't be very beneficial for me to be the one to be power of attorney for them, just from the standpoint of my dad actually had a stroke 2 years ago. If I was the healthcare power of attorney, and I'm 9 hours away, he needed medical assistance right away, and he needed people to be making decisions for him right away. In that case, if I'm not there to make that decision, the hospital might make decisions that he necessarily wouldn't have wanted.
okay.
So yeah, I would say it's best to have it be somebody who's close. If you have a really close friend or another extended family member or something, put that on there.
So what if that person you have on there was out of the country on vacation?
So that is where successor powers of attorney.
So the one we were talking about earlier, that time with that span that we're,
Well, you could do that, or you could even just have it written into the original power of attorney,
okay?
where if you have a successor, at that point, the person who's out of the country, they're incapable of fulfilling that power of attorney. So now it drops down to the successor.
Okay.
So that's why having successors is so important for those types of cases. Yeah. But definitely let your family know. Me and all my brothers and everybody else in the family know. My one brother that's closest to my parents right now, he's the one in charge of all of that, which totally makes sense. So we would know that. We would have to go talk to Dan and be like, hey, what's going on with Daniel? Whatever. Yeah. Things to keep in mind. The agent should understand and agree with your medical preferences, kind of like we've already talked about. Make sure you're on the same page with them. They should be willing and able to act on your behalf and follow your wishes. Again, going back to pick somebody with a backbone. Pick somebody who's going to actually stand up for what you want done for you. Your medical providers cannot serve as agents. You can't pick your family doctor or your surgeon or whoever it might be. You can't pick them to be your healthcare provider or your healthcare power of attorney, sorry. Medical providers may object based on conscience, policy, or standards. So if your healthcare power of attorney is saying something, and the medical providers are like, that makes no sense right now, they can object to it on certain cases. They would have to have very good reasons for why they're objecting to your agent, but they can if you're not. And again, it goes back to why you want to make it specific. Okay. Avoiding potential problems. Be as explicit as possible about medical preferences in your living will. So, if you have a living will, go ahead and be as explicit as you possibly can, because it's going to make it easier in the long run for your power of attorney and for your medical providers. Communicate wishes to the agent and family members to avoid disagreements. Whether somebody agrees with it or not, if you are telling them this is how it's going to be set up, they kind of have to go along with it at that point. Consider durable healthcare power of attorney to avoid potential delays in verification of events such as incapacitation. Again, going back to, if you don't have it durable, if you have it as a springing power of attorney, a doctor has to basically sign off and say, yeah, this person can't make decisions for themselves anymore. Now it goes into effect. And like we were just talking about, name an alternate or successor agent for those specific reasons. Of if that person's not around to do the job, you want somebody who's on par with that. Changing your mind, very similar to the financial ones where while you have capacity, you can cancel it. So if with my dad, specifically when he had his stroke, for probably a month or so after it, you could very easily tell he didn't have all his faculties about him. And he could not have changed his healthcare power of attorney at that point because he was not in his right mind to be able to make those decisions. So make sure, get things set in place before anything happens so that you can do that. Again, it's just notifying your current agent in writing, requesting the documents back, signing a revocation, having that notarized, and then alert any of your medical providers by giving them a copy of that revocation. And then ensure that if you are creating a new one, it has language in there to revoke any of the older versions of that. So, power of attorney recap here. Recognize the potential for inability to act on your own at some point. More than likely, unless we die in some sort of accident, power of attorney is going to go into effect at some point in your life, more than likely. So recognize that and make sure to set it up sooner rather than later. Granting financial power of attorney and healthcare power of attorney allows you to prepare for that possibility. It gets you on the right side of it so everybody's kind of in similar mindset and knows what you want before things happen. As long as you are able to, you do retain the right to make any of your own decisions. Don't fall into, if you did sign power of attorney for somebody, don't fall into the fact that they say like, well, nope, you gave me power of attorney, you gave up those rights, you can't make those decisions now. Nope. As long as you have your wits about you, you can make decisions up until the day that you die. So don't ever fall into that. Don't ever say, oh, okay, well, yeah, I did give you power of attorney. I guess you can do whatever you want. You can change your mind while you're able to do so. As long as you still have your faculties, like we talked about, you can still make those changes. Your responsibilities. So just last couple things here. Choose an agent who will best represent you. Ensure the POA documents represent your wishes and are legally sound. Again, just going to say it again here. This is not legal advice. If you have a lot of in-depth questions, go talk to an attorney, talk to a lawyer, and they'll be able to help you out with that. And one of the biggest things, share copies of those documents with those who need to know. You can set up power of attorney for somebody and they could have no clue about it. That is possible to do. If you set somebody up as power of attorney, let them know. The last thing somebody wants to have happen is like, hey, this person like has surgery that they're going into in 5 minutes, but you need to make a decision for them. Like, no, I don't. What are you talking about? That would be just cruel to that person. So let them know who needs to know that they are your power of attorney.
Are digital copies, like, can they be accepted?
Yes.
I mean, everybody's got a smartphone and they can keep photos or whatever, and
Exactly. As long as you can see that it's been notarized and everything. Again, it really depends upon that institution that you're giving the power of attorney to, if they'll accept it or not. But we've accepted power of attorneys where it's like somebody's mailing it or emailing it to us from, they're down in Arizona.
Yeah.
They're sending it to us via email so that the person up here can take care of stuff for
I
them.
mean, I'm thinking like in the case of a medical, the last thing someone's gonna, if you're rushed to the hospital, are they gonna stop and search for the medical power of attorney?
Take care of it.
They really aren't. No.
Yeah, so,
Exactly.
and I mean, like, I primarily do Sanford, so they would have maybe a copy on file even,
Correct.
or, you know.
Yeah, and that's what I would say.
Thank you.
If you know something, like you know that Sanford is your primary care provider or whatever, and you have healthcare power of attorney, put it on file with them
Okay.
so that they already have it. That is good to do. But like you're saying, if there's an emergency, you're driving out to Wisconsin somewhere, and they're just gonna bring you to the nearest hospital. They're not gonna do anything like that. So
Okay.
I know we personally do, and I think most places would accept an electronic copy of that. But I can't speak for them.
Yeah, yeah. That's where the legal people can tell me.
Exactly, yeah, yeah. I would assume most people would do it, but there's an exception to every rule. What's the saying, like, once there's a rule, just break it because there's gonna be an exception or something like that. So, but yeah, I think that is it, yeah. Any other questions or anything, final things? All good?
So as a husband and wife, is it a good idea to have separate ones? I mean, you were mentioning you and your husband.
Well, this is why I came as big. He's just got his person he wants, and I have a husband and wife, which he has a backbone, and she's kind of on that, she's soft but not soft, but the two of them together make really good choices, and I know that. And then, but he's got this buddy that he's known his whole entire life, and I'm like, that's fine, but I really want these two for me, so. That's why I was asking, is it better for us to have it separate, but we're joint in everything, so it's kind of a.
That's where it does get difficult, isn't really the right word, but it does come down to who stays alive longer realistically. Because if he stays alive, he'll probably put his buddy. If you stay alive longer than him. you'll
So we
have
could
that
change it,
conflict.
it's not.
You can, yeah. It's not something it's never something that's set in stone. You're never going to be able to change it.
And
as
there
far
are
as
three people that are really
goes.
decent, they're just not the argumentative type, they would make that decision together, you know what I mean? It's not like I've got one like bullheaded person that.
Yeah, bull in a china shop. I'm just
Right,
gonna do
exactly.
whatever, it doesn't
No,
matter.
they're pretty much all on that kind of same page.
For sure.
So in like the scenario you're given, if your husband goes into the hospital, the person you listed as a power of attorney, what he says takes precedence over what you say.
Well,
As
If-
the way.
If they are,
I mean, I would think his power of attorney would take into consideration what you would want, but because it's a legal document, does his buddy now take precedence over
Override
what
that?
you, override what you want?
So wouldn't you have your spouse then be the first, be the
Primary.
first primary
yeah,
person?
and then list the
And
other,
then
your
list
three.
someone else?
correct, yep, exactly like that. Yeah, it's best to have them as the primary and then have the other people as contingents. So, I have seen people though where it's, they're both getting kind of fragile and they're both kind of just like, we just want our kids or whoever it might be, we're just gonna give it to them because who knows what's gonna happen in the long run. And just make it easier. Because that is something where, for a successor power of attorney to go into effect, we need something saying that original person can't or won't fulfill their duties. So if your spouse passes away, but you never let us know about that, the successor power of attorney, we're going to be like, sorry, it doesn't matter. We need some sort of documentation, death certificate.